Dr. Syme has been in medical practice for 45 years, primarily as a urological surgeon. He has extensive experience with cancer patients and people with severe spinal injuries, and it's upon this experience that he draws in his recent book, A Good Death, an argument for voluntary euthanasia. He's been an advocate for medically assisted dying for nearly 20 years, having been president of Dying with Dignity Victoria for 10. Please welcome Dr. Rodney Syme.
I thank you most sincerely for the opportunity and the honour as a medical practitioner to present this oration on the subject of a good death, a challenge to law and medical ethics. What is a good death? Well, it's the antithesis of a bad death. In my view, a good death is not what Philip Ariès described as a wild death, an unprepared death without peace, especially in the midst of futile attempts to prolong life. Nor, as Dylan Thomas so famously wrote, do not go gentle into that good night, rage, rage against the dying of the light. Some might see the phrase a good death as an oxymoron. Philosopher Margaret Pabst Batten coined the term least worst death, which may in reality be nearer the mark. It is clearly highly subjective. What you regard as a good death is a good death for you. It may not be for me. For example, some Catholics see salvific value in suffering at the end of life. But research shows that for most people, the issues are clear. A good death involves acceptance of the reality of approaching death, which allows clear communication with family and friends of their value to you and their place in your life. A good death requires a calm state of mind, devoid of toxic anxiety. It requires a minimum of suffering, and certainly not intolerable suffering in the broader sense of that word. And for many, it requires control of the dying process, with the ability to choose when, where, and how one dies. How then do our current situations stack up against that model? Let me state 6 givens or unarguable medical positions. The first given, that dying may be associated with intolerable suffering. The second given, that palliative care cannot relieve all the pain and suffering of dying patients. This is agreed by Palliative Care Australia. The third given, some suffering will only be relieved by death. The fourth given, some patients rationally and persistently request assistance to die. This has also been acknowledged by Palliative Care Australia. And it is well expressed by Gert and his colleagues, who said, when patients have terminal illnesses, it is generally the case that when they want to die, it is rational for them to choose death. Such requests have been measured in a palliative care unit. Hunt and Maddox recorded the views of 331 of their patients who died in palliative care over a 2-year period. 11% said, I wish it would hurry up. 6% said, could you hurry it up? And another 6% said, please do something now. The fifth given is the doctor's duty to relieve suffering. This is a long-standing responsibility. In the 18th century, in his lectures on the duties of a physician, Dr. John Gregory stated, it is as much the business of a physician to alleviate pain and to smooth the avenues to death when unavoidable, as to cure diseases. This is mirrored in modern times by New York palliative care specialist Diane Mayer, who said, a peaceful death must be acknowledged as a legitimate goal of medicine and as an integral part of the physician's responsibilities. If only it were as simple as just saying so. While this principle has not altered from Gregory to Mayer, the manner of its implementation has done so, and yet it is still the subject of bitter debate. The sixth given, the doctor's duty to respect autonomy. When I entered medical practice in 1960, it was into a world where the doctor thought he knew best. Most patients did what they were told, and discussion was not much encouraged. What a revolution has occurred in the last 50 years. Douglas Martin and colleagues wrote in 2000, "The principle of autonomy is the dominant ethic of healthcare in North America and Western Europe, and of course Australia. Even so, I am afraid not all doctors honour this principle. Most dying patients have a combination of physical, psychological and existential pain, referred to in palliative care as a total pain syndrome." What options does a doctor have facing this situation? I suggest loosely that there are 6 options. The first option: the doctor can reject the request for assistance to die out of hand, shutting the door firmly in his patient's face. Denial by the doctor forces the patient to continue suffering. Of this option, palliative care professor Robert Twycross, even although he opposed euthanasia, said, "A doctor who leaves a patient to suffer intolerably is morally more reprehensible than the doctor who performs euthanasia. Such denial may simply drive that person to seek a violent and undignified end. Denial may even force the person to cease eating and drinking in order to die. This option is clearly unethical." The second option: the doctor may respectfully deflect the request, exploring its origins and attempting to alter them. This is the typical palliative care approach. But it may not succeed. What then? The third option: the doctor may discuss refusal of treatment, which may hasten death, with a promise of intensive palliation. But there may be no treatment to refuse, and no proportionate palliative treatment. The fourth option: the doctor can provide increasing doses of morphine, which become lethal by addition. Morphine has been used for easing and hastening death for centuries. It is extremely valuable for relieving pain, but even massive doses, it will not relieve all pain. In my book, I describe Betty's suffering from neuropathic pain due to spinal cancer. Morphine will not relieve such pain. Only an anaesthetic will do so. Morphine also depresses respiration, so that whilst it may ease pain, it may also hasten death. It is the only effective treatment for extreme breathlessness, but paradoxically, it relieves the symptom while hastening death. But a doctor cannot provide morphine for the relief of other non-painful suffering. Medicine's panacea, morphine, is fair enough for intense pain, but it is totally inadequate and harmful for relieving existential and psychological suffering. The fifth option: the doctor can provide so-called deep continuous sedation. This is a complex concept that may be new to many and needs some elaboration. Deep sedation involves the use of sedative drugs to render the patient deeply asleep, often in conjunction with morphine. The patient becomes oblivious of their suffering until death, which may take some days. That is why it is often described as terminal sedation and is often harrowing to all who are close. Terminal sedation is a well-kept secret, rarely discussed in an open fashion. Although in active use in palliative care for over 20 years, I only discovered its use by a strange accident 10 years ago, which I relate in my book. First described in 1988 for terminal restlessness, terminal sedation rapidly became widely used for an increasing range of indications. In 1990, Ventafrida described how he needed to use it in 50% of his patients receiving home palliative care. States of palliative futility, such as unrelievable pain, delirium, breathlessness, fatigue, nausea and vomiting, and psychological and existential suffering, are all common pretexts for terminal sedation in palliative care. Oblivion certainly relieves suffering when morphine alone will fail or is not appropriate. A patient in a coma cannot ingest any food or fluids and will dehydrate and may develop lethal pulmonary complications. However, the provision of intensive care to such a dying patient is futile, as it simply prolongs the dying process. It is not normally done. That person may die of the sedation before they die of their illness. Terminal sedation is a deliberate process which, whilst relieving suffering, can undoubtedly hasten death. Doctors who are morally challenged by this either refrain from terminal sedation, use it in a miserly fashion, or provide sedation with formal anaesthetic protection and hydration, thereby causing their patients to remain in this induced coma for many days before dying. Janet Hardy, in a Lancet editorial, wrote, "The concept of sedation causes considerable unease in many palliative care workers, most of whom are ardently opposed to any form of euthanasia or physician-assisted suicide. There is concern that sedation, as the best means of symptom control in the dying patient, may be underused because of fear of employing terminal sedation. Terminal sedation is justified by some through double effect, a Catholic moral doctrine developed by St. Thomas Aquinas in the 13th century to justify some actions which seemed contrary to established dogma. Broadly speaking, this doctrine postulates that when an action may have both good, relief of suffering, or bad, hastening of death, effects, the action is justified if the bad effect is not intended. To protect the doctor's morals, the creation of oblivion must be slow. Patients may argue that hastening death is not always bad, but they don't have a say in the double effect debate. Ashby says that such sedation is regarded as acceptable palliative care, and such deaths are not reported to the coroner. The decision to use terminal sedation and the acceleration and depth of sedation vary depending on the moral view of the doctor and is very much controlled by the doctor rather than the patient. Terminal sedation thus provides palliation by first eliminating consciousness and ultimately eliminating life. However, one could ask, why should a patient who requests a quick death be subjected to a prolonged dying? The answer, that it is to protect the moral and legal interests of the doctor. Good ethical practice? Not in my view. Except for the dimension of time, terminal sedation is no different from physician-assisted dying, which I am about to advocate. The sixth option, the doctor may explore and finally accede to the rational patient's request and provide physician-assisted dying. That action may involve the delivery of a lethal injection or the prescription of lethal medication which the patient ingests to end his own life. There is only a rare need for the former, and personally I strongly favour the latter. Crucially, the provision of a lethal prescription for oral use leaves responsibility for the decision and the action that causes death where it belongs, with the suffering person. Control remains completely in the hands of the sufferer to choose to end their life, and when or not, as the case may be. It has far greater safety against the possibility of non-voluntary, even though well-intentioned death. The provision of lethal oral medication clearly fulfills a rational and a persistent request for assistance to die a good death. Yet such practice is regarded as unethical by the Australian Medical Association. Thus, faced with a patient with intolerable suffering who is making a rational and persistent request for assistance, a doctor is on the edge of a moral and ethical abyss, but without any safety ropes. It also takes the doctor to the edge of, or even into, the black hole of legal ambiguity. Physician-assisted dying has long been regarded as a serious crime, of aiding and abetting suicide or of murder. Fear of prosecution has inhibited physician-assisted dying, but research reveals that fear of prosecution does not prevent it. Fear of prosecution has also had a limiting effect on the aggressive use of morphine and sedatives. Doctors have, in fact, rarely been prosecuted for such offences, but because of their fear, it is their patient suffering which is multiplied. So, here is the black hole. Deep continuous sedation and physician-assisted suicide, one apparently legal, the other not, both of which are applied to people with intolerable and unrelievable suffering who have requested assistance to die. Both deep sedation and a lethal injection can cause death. A lethal injection clearly does so, whereas sedation does not always do so, or does not always clearly do so. A lethal injection causes death quickly, whereas sedation does so slowly, creating a convenient mirage over the event. Evidence shows that both sedation and a lethal injection can be delivered without the explicit request of the patient. A self-administered oral drug, however, requires the complete control of the patient. A self-administered oral drug will also cause death, but research in Oregon shows that 30% of legal lethal prescriptions are not used. But the prescription has provided valuable psychological palliation to the person with the prescription. We have in Australia no accurate information as to how often terminal sedation occurs. It is completely unregulated and there are no official guidelines, and this for a process which causes death. And of course, physician-assisted dying, whilst it is acknowledged that it occurs, is also unreported and unmeasured. In many ways, the distinction between these actions is that of time. In fact, deep sedation has been dubbed slow euthanasia, defined as the clinical practice of treating a terminally ill patient in a fashion that will assuredly lead to a comfortable death, but not too quickly. One cannot help asking, how fast is murder and how slow is good practice? Where is the line? How can one draw a line? It is the absence of specific law for the medical profession that is responsible for the black hole. Let me explain. Medicine is a particular activity which brings its practitioners in close proximity to death and the causation of death. Yet despite being in this unique and vulnerable position, there is no specific law to protect medical practitioners. A doctor who hastens the death of his intolerably suffering patient by an hour or even a minute is subjected to the same law that applies to a gun for hire, such as Benji Venyamin. The Chief Justice of Western Australia, the Honourable Justice David Malcolm, wrote, "At present, members of the medical profession are placed in a very difficult situation where they have patients who are terminally ill and suffering great pain or mental anguish, who know that matters need to be brought to a dignified end. The dilemma facing doctors is the twin obligations to preserve life and to relieve suffering. The question is, should we leave doctors in this exposed position without statutory protection?" Victorian Senior Counsel Richard McGarvey put it more bluntly. "As the law stands, only the good sense of prosecuting authorities and juries stands between compassionate and courageous medical practitioners and convictions for murder." To illustrate McGarvey's point, To my knowledge, only 2 doctors in Australia have been charged with either murder or manslaughter or aiding and abetting suicide in the last 45 years. Both were acquitted. It is therefore often argued that the lack of prosecutions of doctors should give the profession confidence that they are not at risk. So long as doctors assist patients with drugs of therapeutic value, such as analgesics and sedatives, they do remain relatively safe. Doctors can foreseeably hasten death, whereas in all other circumstances it would be considered manslaughter. The reason is the 1957 English decision of Justice Devlin. Devlin, in the Crown versus Adams, said that a doctor could use narcotic analgesics to relieve his patient's pain and suffering, even though the foreseen but unintended consequence was to cause or hasten death. This is regarded by academic lawyers as a legal application of double effect. However, Professor Skeen and others argue that there is no clear conceptual basis for the use of double effect doctrine in law. It is an English precedent that is generally thought to apply in Australia, although it has never been tested here. Nevertheless, it seems that it allows for the use of narcotics and sedatives that may cause death, and it has saved many doctors from serious charges. It is thought by some that Devlin's precedent applies to the suffering of psychological and existential pain, but it is by no means clear. Despite this precedent having been accepted for over 50 years, there is no clarity as to how or when it applies, and it may be applied without any patient consent. I'm not suggesting that Devlin's precedent has not been helpful. However, such precedents are very cosy in medical situations where the extraordinary range of contexts makes statutory law difficult. But they are lazy law. They apply to a particular situation. Their exact scope can be uncertain. They do not have the careful criteria of statute law and may require some bunny to be the victim of a test case to define their limits. In the case of Devlin's precedent, its scope has actually been enlarged more as a result of unchallenged practice than through test cases. It is somewhat ironic that Devlin's precedent should have such a far-reaching influence, since Dr. Adams used morphine for his elderly patient after a stroke, not a notoriously painful condition, and not one for which morphine would be commonly provided. Moreover, Adams stood to gain under her will. It seems to me that the reasons for the reliance on this precedent is that the whole fabric of good palliative care would be destroyed if a doctor or doctors were charged for alleged excessive use of sedatives and narcotics. Should a doctor have to risk his practice and freedom on such an uncertain basis? It's more likely that his or her patient will suffer rather than the doctor will take such a risk. The Dutch legal system reached a different conclusion to Devlin in similar circumstance. They applied the argument of necessity or force majeure to justify the use of drugs that end life to relieve suffering. English and Australian law seems to be uncomfortable with the idea of necessity, yet to a doctor, the concept of necessity as the basis of the Devlin precedent has more validity than double effect. The Menhennet precedent in Victoria on abortion, another emotional, morally charged issue involving death, was clearly based on the principle of necessity. Why should the legal concept of necessity not also apply at the other end of life, when there is a medical necessity to relieve suffering that will only end with death? It is notable that in the absence of law appropriate to the circumstances of end-of-life medical practice, that the medical profession has, as it were, made the law. I refer in the first instance to the practice of withholding and withdrawing treatment. With the advent of new technologies to save and prolong life, such as artificial ventilation, doctors were faced with the problem of withdrawing treatment that had become futile, but that same withdrawal would directly cause the death of the patient. Doctors feared that they would be charged with murder, but they went ahead anyway because they deemed it the proper thing to do. Prosecutors demurred from charges, and the practice of the law was changed, even if arguments about causation had to be invented, which, according to the law lord Mustall, seems to require manipulation of the law so much as its application in an entirely new and illogical way. The introduction of deep continuous sedation, with the clear potential to cause death, did not have the sanction of statutory law. It relied on an extension of the Devereux principle of legal double effect as applying to the deeply sedating effect of drugs other than morphine. Doctors welcomed this development for, as the Australian palliative care doctor Alexandra Burke said, it provided a readily available means of controlling symptoms and overcoming patient distress where no feasible alternative existed before. Potentially death-hastening treatment was introduced and no one was charged. Compassionate doctors had again remade the law. It seems quite clear that death-hastening medical treatment that is palliative in nature will not be questioned unless someone complains. Like Professor Lowy, I do not disagree with such death-hastening treatment. Nevertheless, such treatment goes on without any guidelines, without the necessity for any second opinions, medical or psychiatric, sometimes without consent, without the necessity to report such action to the coroner, and without any official oversight. There is no knowledge as to how frequently deep continuous sedation is used in Australia. And yet many in palliative care criticise the Dutch, who have subjected their end-of-life medical practices to relentless scrutiny.